In his sixth ground of appeal, Haradin Bala argues that the trial chamber erred in law and fact in rejecting his alibi defense. He submits that the trial chamber erroneously shifted the burden of proof in requiring him to establish that his alibi was consistent and credible, rather than requiring that he simply show a reasonable possibility that the evidence of alibi is true. The appeals chamber considers that the trial chamber correctly satisfied itself that the prosecution had eliminated any reasonable possibility that the evidence of alibi was true and thus committed no legal error in its assessment of Bala's alibi. As to Bala's allegations of factual errors in the assessment of his alibi evidence, the appeals chamber finds his submissions to be without merit. Haradin Bala further argues that the trial chamber erred in law by holding his decision not to give sworn evidence against him. The appeal chamber notes, however, that the trial chamber specifically held that no adverse finding could be drawn on the basis of Bala's decision not to give sworn evidence, and that he has failed to show that his decision not to testify was in fact held against him. Lastly, Haradin Bala submits that the trial chamber erred in failing to provide a reasoned opinion for the rejection of his alibi. The appeal chamber notes, however, that the trial chamber thoroughly considered Bala's alibi defense in a 9-page section of the trial judgment and finds that the trial chamber offered a reasoned opinion for its rejection of Bala's alibi. Haradin Bala's sixth ground of appeal is rejected. In his eighth ground of appeal, Haradin Bala submits that the trial chamber erred in fact when it found witnesses L04 and L06 to be credible despite obvious inconsistencies between their post-testimony interviews given to the prosecution and their prior statements made to Serbian authorities. The appeal chamber notes that the trial chamber found the witnesses to be honest and credible after having carefully examined their testimonies and numerous factors touching upon their credibility. The appeal chamber concludes that in light of the fact that the evidence of several other witnesses corroborated much of their respective testimonies, a reasonable trier of fact could have found these witnesses to be credible despite the identical discrepancies in their testimonies relating to the length of their interviews with Serbian authorities. Haradin Bala's eighth ground of appeal is therefore rejected. I will now turn to the appeal of the prosecution. In its first ground of appeal against Haradin Bala, the prosecution submits that the trial chamber erroneously failed to find that Bala was a member of a joint criminal enterprise and thus individually responsible for the crimes committed in furtherance of a system of ill treatment in the Lapušnik prison camp, and for those crimes which were reasonably foreseeable as a possible consequence of this system. The prosecution argues that a systemic joint criminal enterprise existed. First, the prison camp was run by the KLA. Second, the conditions in the camp amounted to a system of ill treatment. And third, the KLA soldiers in the camp intended to further this system of ill treatment. The prosecution argues in particular that the identification of the members of a joint criminal enterprise beyond being members of that enterprise is not an additional element of joint criminal enterprise liability. The appeal chamber does not consider that the trial chamber adopted an erroneously narrow approach to the identification of the participants in a joint criminal enterprise. Rather, it is clear that the trial chamber was not satisfied that the prosecution had adduced sufficient evidence of the identity of the alleged participants in the joint criminal enterprise to establish that a plurality of persons sharing a common plan existed. The prosecution alternatively submits that the trial chamber erred in fact in failing to draw the only reasonable inference from the evidence, namely that members of the systemic joint criminal enterprise were sufficiently identified by their category as KLA soldiers in the Lapušnik prison camp, including the three accused. The appeal chamber finds that the trial chamber did not commit a factual error when it found that there was insufficient evidence to identify a plurality of persons who furthered the common plan to commit cruel treatment in the Lapušnik prison camp. While the trial chamber's factual findings show that KLA soldiers systematically committed cruel treatment and torture in the camp, the trial chamber was not satisfied that these KLA soldiers were participants in a systemic joint criminal enterprise to commit these crimes. The trial chamber did not err in this respect because it reasonably held that it could not be ruled out that rogue KLA soldiers or so-called outsiders to the camp for personal reasons, such as revenge, mistreated or killed civilian detainees, and not in furtherance of any common plan. The prosecution further submits that any member of the alleged systemic joint criminal enterprise who contributed to an outsider's crime must be considered as having at the same time committed this crime together with the outsider in a basic joint criminal enterprise. The appeal chamber finds, however, that Bala was not given adequate notice of such an alternative basic joint criminal enterprise charge. Hence, the appeal chamber does not consider it appropriate to address the merits of this argument. Alternatively, the prosecution submits that Bala would incur individual criminal responsibility for crimes committed by outsiders as an aider and abetter. The appeal chamber is not satisfied, however, that it is the only reasonable inference from the evidence that in addition to the convictions for aiding and abetting already entered by the trial chamber, Bala incurs criminal responsibility for having aided and abetted other crimes of cruel treatment and torture. It was open to a trier of fact to conclude that the evidence did not show beyond reasonable doubt that Haradin Bala knowingly provided substantial assistance as an aider and abetter to each act of cruel treatment or torture in the prison camp. As a result, the prosecution's first ground of appeal is rejected. In its alternative second ground of appeal, the prosecution submits that the trial chamber erred in exercising its sentencing discretion by sentencing Bala to 13 years of imprisonment. First, the prosecution argues that the sentence does not reflect the gravity of Bala's crime. Second, that the trial chamber erred in its assessment of mitigating and aggravating circumstances. And third, that when comparing his sentence to that of others, the sentence imposed is manifestly inadequate. The appeal chamber is satisfied that the trial chamber did not err in comparing the crimes for which Bala was convicted with those committed by other KLA members when assessing the gravity of his crime. Furthermore, the mere submission that the trial chamber gave insufficient weight to Bala's role as a committer or aider and abetter does not show that the trial chamber ventured outside its sentencing discretion, and the prosecution does not establish an error in this respect. As to the prosecution's arguments in relation to the mitigating effect of his acting under orders and the absence of a sadistic motive, the appeal chamber notes that these factors were not considered by the trial chamber as mitigating circumstances, but were instead taken into account as particular circumstances in the assessment of the gravity of the crimes. The prosecutor does not show that the trial chamber committed a discernible error in this respect.